Conservative analysts such as Jonathan Turley and Stephen Halbrook are applauding 8th U.S. Circuit Court of Appeals Judge Dwayne Benton for his recently issued opinion in the case called Worth et al. V. Jacobson. But although it is a decision that blocks the state of Minnesota from prohibiting gun licenses, so-called, for people who are aged 18, 19, and 20, Judge Benton actually reaches this positive conclusion by utilizing a faulty approach to the Second Amendment. Hi everyone, I'm Gardner Goldsmith for MRC-TV, and here's the story. As historian Halbrook reports for Reason, Judge Benton's majority decision partially hinges on the recent Supreme Court decision in the case called United States versus Rahimi. Now, that regarded a man named Zacky Rahimi, a person who had a restraining order on him and was blocked from having a gun per an interpretation of the 1968 Gun Control Act. And Judge Benton's decision relied partially on the second level, so-called, of the Bruin standard analysis from 2 years ago in the Supreme Court case of New York Rifle and Pistol Association v. Bruin. Now, in this case, the judge determined that the state of Minnesota blocking people who are 18, 19, and 20 years old from getting gun licenses is substantively different from blocking a person with a restraining order on him. Well, that is false. Neither the age-restricted person nor the man with the restraining order has actually been given any due process, convicted of a crime, or put in jail where he could be disarmed. A restraining order is applied without any conviction of a crime or normal due process. Thus, just like people between age 18 and 21 have not been convicted of crimes, so is the person on whom the government has placed a so-called restraining order. If a person isn't in prison and not under arrest, then the government must be deeming him or her either safe enough to be in society, or the government has not proven a case in court to remove that person from society and place him or her in jail. Now, this raises the eternal question that runs through the flawed blocks of gun ownership idea found in the 1968 Gun Control Act. And that is, if you in the government think that a person is safe enough to not be in jail, then why is he not safe enough to exercise his right to keep and bear arms outside of jail? Pretty simple. Well, as Halbrook notes, Judge Benton then mixed the two-tier Bruin analysis into this mixture, an analysis of gun ban statutes that requires first a reading of a statute to see if its wording comports with the actual wording of the Second Amendment, and then second, a reading of the statute to see if the proposed infringement has an analog somehow to some other infringement that might be found in a U.S. jurisdiction after the adoption of the Bill of Rights. Well, perspicacious viewers likely will notice an incongruity. No, actually a QED in the two standards. And we'll return to that. But first, let's see what Mr. Holbrook wrote for Reason. Quote, Minnesota argued that at the founding, states restricted guns in the hands of irresponsible or dangerous groups, such as 18 to 20-year-olds. In reality, no state banned carrying guns by that age group. Quote Rahimi, we reject the government's contention that Rahimi may be disarmed simply because he is not responsible. That concept is too vague and elusive. End quote. Indeed, not only did no state ban people in that age group from carrying arms, the Second Amendment strictly forbids such government activity, including the common contemporary euphemism gun licensing. And of course, the militia was considered to be the population of gun-bearing aged individuals in society, which often meant teens aged 13 or 14. Let's remember, Revolutionary hero Nathan Hale had barely turned 21 when he was hanged by the British. Halbrook adds, quote, "A historical analog that remotely resembles the Kerry ban," the court noted, "will not suffice." Then Judge Benton looked to Rahimi for the test. A court must ascertain whether the new law is relevantly similar to laws that our tradition is understood to permit. As Rahimi added, why and how the regulation burdens the right are central to this inquiry, end quote. And this is where Judge Benton fails, as does the so-called two-tier Bruin standard. The first level of Bruin analysis requires courts to see if a gun grab statute conforms with the wording of the Second Amendment. But the second level lets courts see if the statute in question is analogous to some historical example of a gun grab. Meaning the second level undercuts the first level, because the first level requires courts to see if a statute breaches the strict wording of the Second Amendment, and that wording says, shall not be infringed. Logically, an infringement of any kind cannot stand under the first level of the strict wording of the Second Amendment. Judge Benton's claim why and how the regulation burdens the right are central to this inquiry is not only incorrect for the inquiry that he just adjudicated, it is always incorrect. The Second Amendment doesn't offer exceptions to allow for infringement. It doesn't say shall not be infringed unless a judge or a government can come up with an excuse as to why they are infringing, or they can purport some comfy way how to grab a gun or block its purchase. The Second Amendment is universal and explicit. Shall not be infringed. The British Provost Marshal, who oversaw Nathan Hale's execution at the gallows in 1776, reportedly denied him a Bible and the attendance of a clergyman. He was denied a trial. At every level, the British government turned away from recognizing and respecting Nathan Hale's rights. Are we to celebrate Pyrrhic victories today that treat our natural rights in a similar fashion? Decisions that superficially appear to defend the right to keep and bear arms, but which rest on overt and systematic government carve-outs, undercutting our rights? Any clear analysis of this ruling, of Rahimi, and of the two-tier Bruin standard reveals the undeniable truth that the judicial decision makers are not serious about defending our rights, even as some folks celebrate what appears to be a win in the short term. Thanks for watching, everyone. Please like and subscribe. Find us on Rumble, where they don't censor us. Please follow us there and share the videos as far and wide as you possibly can. And don't forget, of course, we are still on YouTube. Double check that you're subscribed there if you still watch us over there, because, of course, they censor and people seem to fall off on the subscriptions. I don't know how that could be possible. You can also find us all the time at MRCTV.org, MRCTV.org, where the whole team is doing great work. And, of course, you can help us by contributing to the Media Research Center and checking out the MRC TV store. You can find us on Facebook, on TikTok, on Instagram, on Twitter/X. And if you want to find me on Gab, I'm at Gardner Goldsmith on Gab, and on Twitter/X. You can find me as at Gard Goldsmith. Thanks so much for watching, everybody. Please share the videos, especially for people who are interested in rights and freedom and how contemporary minds don't seem to get it. Amazing. For MRC TV, I'm Gardner Goldsmith.
I want to invite you as my guest on a very special, once-in-a-lifetime, 7-day post-election cruise in the Caribbean. It's going to be a blast.